We are going to find out that there were, in fact, distinct ties between the Democratic Party and this alleged bird dogger, Shirley Teeter. And with that said, if you like my videos, you like my content, you know what to do. Like, share, subscribe, hit the notification bell, drop a comment in the comment section below because it feeds the algorithm. Viva Frei, Montreal litigator turned YouTuber, and this is Winnie the Westie back in the office to cover another vlog. Now, I talked about this story in one of my live streams from earlier this week, but I think it needs its own dedicated vlog because there is so much more to the backstory of this story that it needs its own detail, it needs its own highlights,
and it needs its own dedicated video.
To truly understand this story, we need to go all the way back to 2016, give or take, at a Trump rally where there was a certain act of alleged violence against a certain individual named Shirley Teeter, who was 69 years old at the time, a very sympathetic victim at that, and this is what is alleged to have occurred at the time.
She was one of our activists.
She was one of your activists
who had been trained up to bird dogs.
Yes.
So the term bird dogging, you put people in the line at the front, which means they have to get there at 6 o'clock in the morning, so they're getting the front of the rally so that when Trump comes down the rope line, they're the ones asking him the question in front of the reporters because they're pre-placed there. To funnel that kind of operation, you have to start back with people 2 weeks ahead of time and train them how to ask questions.
Right.
You have to train them to bird dog.
Project Veritas went undercover and got video footage of people admitting, people proudly boasting to working directly with the DNC, orchestrating these types of events at any Trump rally, getting these people who they referred to as bird dogs to get people provoked, to strike them, to do whatever, to cause a scene that can be reported by the media in order to demonize the Trump campaign. They got undercover video footage of people admitting to having done this, making the connection to Shirley Teeter that she might have been the bird dog that one of these individuals was talking about in one of the undercover videos, and that itself, well, that was reported on by CNN, except this is how they reported on that.
Undercover videos produced by discredited conservative activist James O'Keefe suggest it was Democratic operatives, hired political activists, working in coordination with the DNC to instigate violence and incite reactions at Trump rallies. According to the undercover videos, it was this man the Democratic National Committee turned to organize the work. Bob Kramer is the husband of Illinois Congresswoman Jan Schakowsky.
Okay, so now you know a bit more of the backdrop. You have these individuals purporting to work directly with the DNC, getting what they refer to as bird dogs to go to protests, to provoke people to assault them so they can use it for political purposes. Well, Shirley Teeter didn't much like this reporting, so she decided to sue Project Veritas for defamation and other reasons. She also sued the guy who allegedly assaulted her, Campbell, and they had their own litigation between them, which subsequently settled, but she sued Project Veritas. Her lawsuit was dismissed on a directed verdict, and if you don't know what a directed verdict is, I refer you to old Viva, who is a very awkward and cringeworthy Viva. Watch this.
The defamation lawsuit filed by one Shirley Teeter against Project Veritas and James O'Keefe was recently dismissed, and it is impossible to understand what exactly is going on unless one understands what a directed verdict is. This sort of slipped under the radar even for people who were following the story. An individual named Shirley Teeter was suing Project Veritas and James O'Keefe for defamation. And during the 2016 election, they made a name for themselves by going undercover and exposing what was going on in the Democratic election campaign. One of the stories they reported on was a story about an individual named Shirley Teeter, who's an elderly lady who got assaulted at a Trump rally. Project Veritas covered the story and then showed undercover footage that they had of one of the Democratic campaign organizers who was caught by this undercover camera talking about a strategy being used by the Democratic campaign called bird dogging. It basically is the tactic of hiring or promoting or encouraging activists to show up at the rallies of their political adversaries to start some kerfuffle, leading to an incident that allows the campaign to portray the other campaign in a negative light. And this individual was talking about a bird dogger who was an elderly lady from North Carolina who had COPD, who was one of their operatives, who showed up at a Trump rally ostensibly for the purposes of instigating a situation or an event. And one such event occurred. Project Veritas made the report detailing all of this, and although Shirley Teeter was not named by name, it is apparently sufficiently clear that that was who the campaign was talking about being their bird dog, or who was going to engage in bird dogging at a Trump rally. Shirley Teeter sued James O'Keefe and Project Veritas for defamation because the reporting painted her in a negative light as an activist bird dogger, as opposed to a totally innocent victim who showed up at a Trump rally to protest and got assaulted by angry Trump supporters. Shirley Teeter opted for a trial by jury jury and a federal judge just dismissed the lawsuit outright after the trial had been held, but before the jury could come to a decision. And I'm a lawyer, and I didn't understand what happened or how it happened, and I had to look into it because the articles I read didn't even mention the term directed verdict, let alone explain what it was, and that is critical in understanding what exactly happened. But I've been following this story loosely, and I understood that it was going to be a trial by jury, so when I heard that a judge dismissed the lawsuit, flags started going off in my head. How could this happen? How could a judge dismiss this lawsuit as opposed to the jury whose very purpose it was to determine that very question? And in looking into it, I discovered that there's something called a directed verdict. The judge who dismissed the lawsuit before it even got to the jury was appointed by George W. Bush, presumably a conservative judge appointed by a Republican George W. Bush, dismissing a lawsuit based on a directed verdict. I can understand how both sides are going to view this outcome, but I do not interpret this situation through political blinders. I leave that to you.
Shirley Teeter not only had her lawsuit against Project Veritas dismissed by way of directed verdict, but the judge who dismissed her lawsuit also ordered her to pay Project Veritas costs, and when Project Veritas sent the bill of costs to Shirley Teeter, she said, "I don't have the money to pay her costs," and asked the court to dispense her of the obligation to pay Project Veritas costs for her failed lawsuit. A clerk of the court actually initially dispensed Shirley Teeter of paying the costs that the judge originally ordered her to pay, and Project Veritas obviously did not like that decision and appealed that decision to a judge, and that is what we are going to read. Highlights from the decision ordering Shirley Teeter to pay the cost of Project Veritas, because talk about adding insult to injury. What the judge says about Shirley Teeter in this decision, it's a judicially polite way of calling her a liar. In the United States District Court for the Western District of North Carolina, Asheville Division, Shirley Teeter plaintiff versus Project Veritas Action Fund, Project Veritas, and James O'Keefe III defendants. Memorandum of decision and order. This matter is before the court on the defendant's motion to review clerk's order denying costs. Background. The present action is one of two actions filed in this court arising from an incident that occurred between the plaintiff Shirley Teeter, plaintiff, and Richard Lamar Campbell outside of a political rally in Asheville, North Carolina on September 12, 2016. On September 14, 2017, the plaintiff initiated the present action asserting claims for defamation, libel, slander, and unfair and deceptive trade practices against defendants Project Veritas Action Fund, Project Veritas, and James O'Keefe III arising from their publication and dissemination of videos related to the incident between Campbell and the plaintiff and of a political operative purportedly commenting thereon. In the companion case, Mr. Campbell asserted claims against the plaintiff of assault and battery, malicious prosecution, and defamation, and the plaintiff in turn asserted counterclaims for assault and battery, defamation, libel, and slander against Mr. Campbell. The two cases were consolidated for the purposes of conducting discovery. 5 of the 6 attorneys who currently represent or previously represented the plaintiff in this action also represented the plaintiff in the companion case against Mr. Campbell. To simplify this somewhat complicated procedural background, not only did Shirley Teeter sue Project Veritas et al., but Campbell, the individual that Shirley Teeter alleged assaulted her, sued her, she countersued him, and they ultimately entered into a confidential settlement agreement between the two of them in what is referred to as the companion case. It doesn't take much to put 2 and 2 together, or in this case 6 and 1 together, 6 attorneys and 1 plaintiff together, to know that
This does not make a lick of sense.
But the bottom line, Shirley Teeter says, "I don't have the money to pay the bill of costs that the court ordered me to pay." Project Veritas' principal argument is that the plaintiff Shirley Teeter has failed to establish that she is in fact unable to pay the costs owed by her to Project Veritas, despite what she said in her affidavit. The plaintiff contends that she is unable to pay the costs at issue, and this was the basis for the clerk's determination, to which the defendants now object. In support of her argument, the plaintiff has submitted her bank records from January through December of 2019 and an affidavit signed by the plaintiff in August of 2019 detailing her monthly income and expenses. In her affidavit, the plaintiff states, "I have no money to pay for defendants' litigation costs. I had or have no money to pay my lawyers the costs and expenses they incurred on my behalf in representing me. My lawyers did not agree to pay the costs and expenses they incurred on my behalf, and they certainly did not agree to pay any award of costs incurred by defendants." Well, it's all fine and dandy that Shirley Teeter says in an affidavit that she doesn't have the money to pay the costs that the court ordered her to pay for her failed lawsuit, but there is that pesky thing of that settlement between her and Campbell in the companion case. While the plaintiff attests in her affidavit to having no funds with which to pay the defendant's costs or the costs incurred by her own attorneys, upon questioning at the February 25, 2022 hearing, plaintiff's counsel acknowledged that the plaintiff received a substantial payment from Mr. Campbell in January of 2019 as settlement in the companion case. Plaintiff's counsel further explained that half of these settlement funds were used to pay the plaintiff's attorneys, some of whom represented the plaintiff both in this case and in that companion case. You swear in an affidavit to the court that you don't have the money to pay the court costs, and yet your attorneys confirm that you received a substantial settlement payment from Campbell in the companion case. Okay, that makes a lot of sense. evidence. And the judge, picking up on this apparent inconsistency in Shirley Teeter's story, concludes as follows. Therefore, when the plaintiff submitted a sworn affidavit to this court that she, quote, had no money to pay my lawyers the costs and expenses they incurred on my behalf, end quote, she was less than fully candid with the court. That is the most polite way on earth for one person to call another person a bald-faced liar. And the judge doesn't stop there. The judge then goes on to rightly question how an individual with no money to pay their attorneys has 6 attorneys on file representing her. However, the plaintiff's receipt of a substantial sum in the Campbell settlement also does not fully explain the plaintiff's financial arrangement with plaintiff's counsel. The plaintiff was represented by 6 attorneys in this matter, all of whom were from outside of this district and one of whom was from out of state. 4 of these attorneys were present for the entire trial. The plaintiff had the sort of representation not ordinarily available to litigants in her position. In the court's experience, there are only a few scenarios where multiple out-of-town attorneys would be willing to become involved in representing a plaintiff who, by all accounts, is indigent and therefore cannot pay the costs of the litigation herself. Going back to the undercover reporting by Project Veritas that we looked at the beginning of this vlog, some people might come to the conclusion that it's possible, it just might be somewhat possible, that 6 attorneys representing Shirley Teeter, a woman who some people in undercover footage admitted might have been a political operative bird dog, it's possible that there might be some politics involved and that other people might be paying these 6 attorneys to represent Shirley Teeter on alleged bird dogs. Mr. Sasser did not explain, however, why 6 out-of-town attorneys would agree to take Ms. Teeter's case on a, quote, primarily pro bono, end quote, basis. Moreover, Mr. Sasser did not explain why, once the Campbell matter was settled, that these attorneys continued to represent the plaintiff on a contingent fee basis. After all, the plaintiff's claim was so weak that it did not survive a motion to dismiss at the close of the evidence. Further, Mr. Sasser only raised more questions by his unsolicited statement, specifically disclaiming that the lawsuit was being funded by the Clinton campaign or the Democratic Party. That was not the question that the court asked. However, Mr. Sasser's rush to assure the court that certain political organizations are not involved begs the question of whether some other organization was involved. The court ultimately orders plaintiff Shirley Teeter to pay the litigation costs incurred by Project Veritas, although the court reduces the amount from $23,000 and change to $15,000 and change by excluding certain items that the court determined ought not be included in the bill of costs. For all these reasons, the court finds that awarding costs to the defendants is appropriate in this case. The expenses that may be taxed as costs under Rule 54D1 are set forth in 28 U.S.C. Section 1920 as follows, and you can pause and look those over at your leisure if you're curious. It is therefore ordered that the defendant's motion to review clerk's order denying costs is granted in part, the clerk's order regarding taxation of costs is vacated, and the clerk of this court is instructed to assess costs against the plaintiff and in favor of the defendants Project Veritas Action Fund, Project Veritas, and James O'Keefe III in the amount of $15,920.52. Sometimes when you sue, you're going to lose, you're going to get ordered to pay costs, and in this case, Shirley Teeter lost. Now she's got to pay Project Veritas' costs.
She was what's called a bird dogger. I had no idea what the word meant. And that is apparently someone who goes to political rallies, is funded, financed, or motivated by activist groups. They go to political events to raise a poo-poo, to make a stink, so that it can then be weaponized by the media to go, to demonize the event, the politician, or whatever. Trump rally. This is from May 22, 2019, before I covered it in a vlog. A federal judge has tossed a lawsuit by an Asheville woman who reported an assault outside a 2016 Donald Trump campaign rally. Shirley Teeter filed a lawsuit against conservative group Project Veritas, James O'Keefe, and affiliate Project Veritas Action for defamation, claiming her portrayal in a Project Veritas video ruined her name. Remember what the ultimate defense to defamation is, at least in the States and in Canada, but not in Quebec. Truth is the ultimate defense. Teeter claimed the group portrayed her as a political activist sent to a 2016 Trump rally to cause chaos. Then we get into the incident. Shirley Teeter, who lived in a senior housing apartment a block from the Cellular Center, was among a group of protesters outside the rally. Teeter told to police that she was assaulted following the rally. A South Carolina man was arrested for the assault, but charges were later dropped. Soon after the incident, an online video was released by O'Keefe. Gosh darn, if anybody is doing the Lord's work of journalism, it's James O'Keefe and Project Veritas. Soon after the incident, an online video was released by O'Keefe and Project Veritas claiming to show Democratic operatives planning to incite disorder and violence at Trump rallies. We reported accurately what Scott Fovel, the politically affiliated operative, told us, says O'Keefe. Fovel was the director at the time for a liberal political group called Americans Unite for Change. In the video, Fovel says she was one of our activists. What's unclear is who Fovel referring to in the video. Teeter denied being a political operative. O'Keefe countered, saying the lawsuit was really an attempt to shut down his conservative voice. I believe this is an attack on the First Amendment and press in general by people who politically disagree with us. On Wednesday, May 22, 2019, U.S. District Judge Martin Redinger dismissed the lawsuit. Okay. And then the clerk of the court issued an order denying defendants costs because, quote, the financial circumstances set forth in the sworn affidavit are sufficient to overcome the presumption in favor of awarding costs. When the judge dismissed the action, it said that the defendants shall recover their costs of the action from the plaintiff. Shall and not may. So I presume that the judge is not so happy with the clerk who seems to be overriding the judge's shall with their own determination. In support of her argument, plaintiff submitted her bank records from January through December of 2019 and an affidavit signed by the plaintiff in August 2019 detailing her monthly income and expenses. In her affidavit, she states, I have no money to pay for defendants' litigation costs. I had or have no money to pay my lawyers the costs and expenses they incurred on my behalf in representing me. My lawyers did not agree to pay the costs and expenses they incurred on my behalf, and they certainly did not agree to pay any award of costs incurred by the defendants. I guarantee you the lawyers did not agree to that. But I love this. While the plaintiff attests in her affidavit to having no funds with which to pay the defendant's costs or the costs incurred by her own attorneys, upon questioning on the February 25, 2022 hearing, plaintiff's counsel acknowledged that the plaintiff had received a substantial payment from Mr. Campbell. She had received a substantial payment from Mr. Campbell in January of 2019 as settlement in the companion case. It's always curious when people pay, but sometimes people just pay to avoid a trial. I mean, and in a case of alleged assault between an elderly frail woman and Mr. Campbell, who I believe was not an elderly frail woman, but a man, there might be risk factors in going to trial. There might have been facts that I'm not familiar with the assault incident itself. He might have been guilty. The plaintiff was represented by 6 attorneys in this matter. The plaintiff, who has no money, who's not a political operative by her own affirmation, was represented by 6 attorneys in this matter, all of whom were from outside of this district, and one of whom was from out of state. You suspect, Shirley Teeter, to quote Ben Affleck from Good Will Hunting. 4 of the attorneys were present in the entire trial. The plaintiff had the sort of representation not ordinarily available to litigants in her position. I wonder why. Could it be because these lawyers, I'd love to know, I don't know who they are. I'd be curious to know if they have any affiliations to any political organizations. Thus, the involvement of so many geographically diverse attorneys is a matter that is puzzling to the court. By the way, legalese, when a court says it's puzzling, what they're basically saying is you're a liar. You expect us to believe your lie. Your lie makes no sense, and we don't believe your lie. In summary, people, Shirley Teeter had such a frivolous case, it was dismissed. She entered into a settlement that was an undisclosed confidential amount with the individual she accused of assault. She attested to court that she didn't have the money to pay her attorneys when her attorneys were compelled to disclose to the court a substantial settlement that was paid to her by the other individual while she was simultaneously claiming financial hardships so that she did not have to pay the costs incurred by Project Veritas et.al., who she frivolously sued for a baseless accusation. Another W. So chalk it up to people who fight the good fight. They fight the good fights as plaintiffs and they defend the good fights as defendants. And, the bird dog has left the nest, I guess.